On the phone, it's a pleasure to welcome to the program Professor Brook Baker. He is the head of the Health Global Access Project at the Northeastern University School of Law. Welcome to the program, Professor.
Thank you very much for having me on your show.
Now, let's start with this ruling by the Indian Supreme Court and how Novartis is actually, you've written extensively on Novartis's attempts, it's sort of a three-pronged strategy to maintain their ability to profit off of medicines essentially that have gone off of patent. And let's start with this the Indian Supreme Court decision, and then we will move into the TPP and TRIPS and these other so-called free trade deals that are being engineered as we speak. What happened in India?
Okay, so just a little bit of background before I go directly to the Supreme Court decision.
Great.
Novartis filed for a patent on its medicine called Gleevec in India and Gleevec in the United States. It's a very good anti-cancer medicine that treats leukemia and substantially extends people's lives. Now, the original compound that's used in that medicine was discovered in the early 90s. And at that time, India lawfully had no patent protection on pharmaceutical products because there was no international law requiring such protection at that time. In 1995, the WTO TRIPS agreement that established new standards for international intellectual property protections actually required countries to start granting patents in all fields of technology, including pharmaceuticals. And after that effective date, after it had tweaked that chemical compound a little bit further, Novartis filed for a patent application in India. It's that second patent, and if you as you have it, that's at the subject of this dispute. And basically, when India became compliant with international law, it said, we're not going to allow patents on secondary products, on slight revisions to existing chemical entities and medicines. And so because Novartis had no right when it first made its discovery, it couldn't, in a sense, get retroactive patent on something that was not allowed at the time India amended its Patent Act.
So when we talk about tweaking a medicine, it may be that the tweak can be as I guess as small as changing the way that it's absorbed by the body over what period of time, or that perhaps it's used for different ailment. What constitutes, at least in Novartis's mind, or what would they like that to? What would they like those tweaks to constitute? I mean, in other words, where do they set the bar?
Okay, so the difference between the first discovery, which was made in the early 90s, and the subsequent discovery in a few years later at the end of the 90s, was basically the beta crystalline form of an existing chemical entity. And it's the kind of routine, let's call it product optimization, that a company goes through. It's not exactly that a trained chimpanzee could do it. I mean, I don't want to demean the lab scientist, but it's not heavy lifting, as was the discovery of the original compound, which was actually discovered to have anti-cancer effects. So what they had done is tweak this just a little bit to have a particular crystalline form of a salt, and then claimed a new patent on that. Well, that was not initially granted even in the U.S., but Novartis appealed and eventually won the patent on the secondary crystalline form, 2005. But India has a different standard. It has a standard that it will not evergreen or give secondary patents on minor modifications of known compounds, nor on new uses, what we call new indications for existing medicines, nor on combinations or new formulations or new dosages. basically they said if you do that kind of incremental innovation, we will not patent it unless it has significant therapeutic impact in the treatment or prevention of human disease. And that's the precise issue that was before the Supreme Court of India.
Let's
Novartis was basically trying to get India to adopt an easy-to-meet standard of review on secondary patents. And what India said is, the Supreme Court says, we are against evergreening. We want generics to be able to come to the market when they're supposed to come to market. And we are not going to allow these minor modifications to get patent protection unless you meet a strict standard with respect to significant therapeutic impact.
Now let's
Novartis had no evidence that its second variation had any such impact in terms of treatment of cancer.
And so let's talk about the implications of this practice that in the U.S. is the bar is lower. I mean, because you've written that the generic competition by Indian companies has produced a 99.4% drop in the price of the lowest cost first-line medicines. The figures you give are from basically $10,500 to $61 per person per year. And you write that most of the 6.6 million people living with HIV in Africa, Asia, Latin America are alive because of that steep drop in prices. And the flip side of that, of course, is that in the United States and other developing nations, these minor tweaks essentially allow the patents to continue on for years and years, crowding out, or basically not just crowding out, but essentially eliminating any type of market for generics.
Right. So you're absolutely right. So the basic scenario is when there's robust generic competition, competing at efficient economies of scale, medicine prices drop fantastically. So the new, better antiretroviral medicines that are used to treat AIDS, and particularly most of the 8 million people in developing countries receiving antiretroviral therapy, is now a fraction of a penny of what the same medicine costs in the United States. And that's completely because there's no patent blocking access to those medicines, either in India where they're produced or in African countries where they're largely consumed. Now, so, from our perspective, it's vitally important, one, that we have a lot of countries that are able to, import or make on their own generic copies, but also that there's lots of generic competitors. What the U.S. and Big Pharma are pushing for, including Novartis, is a system that guarantees that they can get additional 20-year monopolies for minor modifications of existing medicines. So let's say they file their first patent in year 1. In year 10, they'll file another one and get 20 years from that. And then in year 20, they'll file another one and get another, essentially 10 years onto their patent. So we know that there are some antiretroviral medicines in the U.S. where the effective patent monopoly is now approaching 40 years because we too easily grant patents for these kinds of minor modifications. If those rules are forced on other countries, low and middle income countries, their patients will be waiting for decades for affordable medicine, and people die during that time period. So this is really a matter of life and death. You mentioned earlier on the broadcast that the U.S. is seeking looser standards for patents on medicines in free trade agreements. The most important such effort right now is in something called the U.S. Trans-Pacific Partnership Agreement negotiation involving 12 countries. And in that negotiation, the U.S. is directly challenging the kind of patent rule that India has in its Patent Act, which basically safeguards against evergreening. The U.S. insists, and this is direct language, that there can be patents on new forms, new uses, and new formulations of existing medicines. So basically, the easy-to-get standard that we have in the U.S. would be imposed on all those trading partners and indirectly on India and a few other countries that are adopting stricter standards.